See, this is what happens. I do that one thing in terms of the adjournment. I do something nice, then everybody thinks I'm nice.
No, you're not nice.
Well, but you did.
Whoa, whoa, whoa. Court calls the case, People versus Tommy Clark.
Michigan Action for the People.
I'm sorry, who are you?
But I did talk to the public defender who's representing us. If Ms. Keating wants to stand in.
I can. I know Mr. Brown was here just a moment ago. We would be asking for an adjournment.
That's right. The council have said there might be some issues that they want to address. And he's going to send me an email. I'll look into it. It has to do with the stop and the search. So that's further investigation.
Got it. Probable cause conference will be adjourned July 2nd, 2024. 9 a.m. Bond will continue. So between now and then, that's a Tuesday.
Tuesday, can you? I'm off on when you can't schedule like a day that I'm off.
Oh yeah, of course. We'll
I'm asking.
find your
Can you
schedule.
not work?
No, I can't do it.
Asking.
I have Tuesday, Thursday.
Thursday
Okay.
will work.
Man,
The following Thursday, Your Honor?
I don't like what?
Would it be possible to do the following Thursday? Your Honor?
See, this is what happens. I do that one thing in terms of the adjournment. I do something nice, then everybody thinks I'm nice.
No, you're not nice.
Well, but you did.
Whoa, whoa, whoa. He said,
He meant that you're fair.
did he say,
I'm not saying taking it.
no, did he say that I was not nice? He did, just outright, unsolicited.
I'm sorry.
He just said that.
You know what I mean?
No, I don't know what you mean. I'm sensitive. I'm hurt now. And now he wants me to do him a favor by giving a day. See, that's what I'm talking
You
about.
just flipped it.
What?
You think I'm nice and they're gonna abuse me, then I say you're not fair, then you.
See?
Let's just get on the balance level.
No, we're never, this is never balanced. You need to understand exactly how this works. No, it doesn't work that way. All right. He's out of custody, so let's do it this way. I'll do it July 11th. That's a Thursday. That'll give you time to have them look at that, and you get a full set of pants before you come back. All right, Bond will continue. Thank you. Court calls the case, People versus Bryant Hargrove.
Public Defender Tina Apple, appearing on behalf of Mr. Harper. Please take name for the record, sir.
Brian Hargo, and I'd like to apologize for my short string. I was wrong.
You were listening.
Yeah.
Okay. That's okay.
They're nice. He looks nice though, color shirt.
Let's just leave it alone.
Yeah. He was gonna say it. He's like, look, like, just stop. You with me. How come? So, Miss Apple, this is a plea.
Correct.
So how come Mr. Wood couldn't do it?
Well,
You sent her up here to do like it's a big giant sandbox. You gotta let him play.
that will be happening soon.
Well,
She had that issue yesterday.
what if I said I'm not gonna do
She
this
didn't come in.
until she's the one doing it?
She
Then
wasn't
what?
able to come in yesterday to help prep, so she had this matter come up, so.
Don't let him take things
Yeah.
from you. You just grab the files. Okay?
It'll happen.
Grab the files and run. And if it gets out of control, just go find Lauren. He'll help you. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilty to an added count 3. And that count 1 would be dismissed, but I don't see what happens when it.
Count 2 would be a plea.
That's right.
Ah, there it is. That's right. It's written in Canadian. Defendant to plead on count 2 on the complaint. All right. So he's going to plead guilty to counts 2 and 3.
Correct.
Count 1 would be dismissed. All right. Very good. Having some more?
Raise your right hand. Do you solemnly swear and affirm the testimony about to give the truth, the whole truth, and nothing but to help you God?
Brian
State your name.
Brian Hargrove.
All right. Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes.
First charge, the first of those charges is the stated count 2 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Though they're gonna have to, they're gonna have to get somebody down here to do something about that. That was painful. 93 days in jail, fine $500 plus court costs. You understand that, sir? Court could order any rehabilitative services or community service the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Sure.
The other count is the added count of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court cost. You understand that?
Sure.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
All right. Now, understanding all of that, sir, do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of use of cocaine, I think it was, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation or parole at the time of this offense?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will because you believe that you're indeed guilty?
Yes.
June 2nd, 2023, at the location of US 12 near Onondaga Street, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
Vodka, about a half pint to a pint.
All right. Were you stopped by the police or was there an accident?
Accident.
There was an accident?
Yeah.
What happened?
I ended up passing out and I went to some trees and that's what I found.
All right. And the police arrived
Yes.
and ultimately you were taken to the hospital? Is that correct? Was there a blood draw?
Yes.
And what were the results of that blood draw?
I'm not sure, Your Honor, but I know.
Your Honor, we would stipulate the results were 0.119.
All right. You don't have any reason to dispute those results, sir, do you? All right. On that date, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yeah.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
All right. Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered and screening and assessment is ordered at 14B District Court. Sentencing in this matter will be
July 25th at 10 a.m. before Judge Washington.
July 25th, 2024. What time? I'm sorry.
10 a.m.
10 a.m. before Judge Washington.
Your Honor. I also like to say, I did complete the Don Farm program, the residential and outpatient. I am now 11 months clean.
Congratulations. That's fantastic. All right, make sure when you go over and do the screening and when you talk to probation over there that you let them know all of that.
Yeah, they are.
Okay, I know with Judge Washington, all of that will make a huge difference in terms of what she does.
Thank you.
All right, take care of yourself. All right. It does call the case, People versus Abdul Dumana. I do believe we have a French interpreter. And Madam Interpreter, if you could, please raise your right hand to be sworn.
You solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment to translate from English into French and from French into English in the matter now before the court, so help you God.
I do.
State your name.
Joanie Messina.
All right, thank you.
Use on behalf of the people.
Nicole Pius, donc c'est elle qui représente les gens.
John Shea, Your Honor, on behalf of Mr. Sumana.
John Shea, donc c'est lui qui te représente, Monsieur Soumana.
All right, what are we doing today?
Qu'est-ce qu'on va faire aujourd'hui?
We are requesting a 2-week adjournment, Your Honor.
On exige un ajournement de 2 semaines, votre honneur.
A complicating factor in this case is
Il y a un facteur compliqué dans ce dossier,
the fact that Mr. Sumana has an ICE hold,
le fait que Monsieur Soumana, il a un sursis avec ICE.
and we are trying to work on that
essaie
before
de-
pushing this case forward.
Et on essaye d'avancer avec le dossier.
We do have discovery. I believe we have everything except perhaps
Je crois qu'on a tout à
body
l'exception,
camera recordings.
donc des enregistrements avec les caméras.
I can do the 27th or the July 2nd.
Donc, soit je peux faire le 2 juillet, soit le 27 juillet.
Because Mr. Sumana is in custody, Your Honor, I think we would prefer the 27th.
Je pense qu'on préfère le 27.
And Your Honor, I have expressed to Mr. Sumana
Monsieur Soumana,
that if we resolve the ICE hold in the meantime,
le dossier avec
That-
ICE,
that we will try to get a hearing in front of Your Honor regarding his bond
on va
beforehand.
essayer d'avoir une audience avant par rapport à sa caution.
Very good. Probable cause conference adjourned June 27th, 2024, 9 a.m. or as your invite indicates. Bond will continue.
La caution va continuer.
Thank you for the court's consideration.
Thank you. Thank you, ma'am.
Thank you.
Tomorrow. See you tomorrow.
On verra demain.
Court does call the case, People versus Omar Anderson.
On behalf of the people.
Good morning, Silvana Reed, Assistant Public Defender with and on behalf of Mr. Anderson, who is approaching. Could you state your name for the record?
Omar Anderson. Thank you.
Your Honor, I was just informed last night that there are some jail calls that were delivered to my inbox after the beginning of this docket today. So I would like to ask for an adjournment so that we can listen to those and decide on how to proceed from there.
Go ahead. What?
That is correct, Your Honor. He was arraigned on May 31st, and between May 31st and prior to his release on June 3rd, including on June 3rd, he made 8 calls to the victim. I do want to note that the underlying allegations here is that he had a valid and served PPO protecting the victim. At that time, he came out and threw a brick through the back windshield of her car, which damaged the front windshield of her car as well, and then fled the scene. Since the calls from the victim, to the victim from when he was in custody, she has since filed to terminate the PPO, and he has been out. I'm extremely concerned that
There was, I just want to make sure I'm clear. There was a PPO.
correct,
He is lodged at the jail at some point.
correct,
From the jail, there are calls being made.
correct. After his arraignment.
Go ahead.
I am extremely concerned at the potential for undue influence on the defendant's part over the victim.
Counsel. Anything?
Your Honor, as I have not had a chance to review any of the information, I just know that there were calls. Again, I would ask for an
But
adjournment.
how many calls between the time that he's incarcerated and arraigned and released? How many calls? You have copies of the calls?
They were just released this morning.
I have not had a chance to download them.
Because I'm gonna let you know, Mr. Allen, my inclination would be to remand him pending some resolution as to what's contained within those calls, because he shouldn't have been contacting her at all. Yeah, defendant's bond at this point will be revoked because I think that his bond, there would have been differences. I need to figure out what's in these calls. And here's the reason, Miss Reed, I want to figure that out. There are these calls being made. There's a PPO in place. There are these calls being made. The PPO is then requested to be lifted, and then this case is still here. And it's a lot of little flags raised by that. So I'm going to revoke his bond. I will give you an opportunity to whoever in your office to try to get through those calls. And then I will consider at any point in time, a request to change that or to do something else. But I think everybody needs to hear, or at least try to hear, what's on these calls. All right.
Do you want me to release the calls to your chambers as well, or?
Why don't you? Because that would then speed up the process if Ms. Reed has something that's in the calls or something that she wants to say why or whatever, or the people for that matter. I don't have to then try to reach out and get them. So yeah, why don't we do that? You wanted this adjourned, correct?
That is correct.
All right, since I'm remanding him, I'm going to put it out just 1 week to the 20th.
Thank you.
So probable cause will be adjourned to June 20th, 2024, 9 a.m. or if your invite indicates bond is revoked at this point. Defendant's remanded. Court calls case People versus Derek Couch.
Simple defender Donnie Lee on behalf of Mr. Couch. Mr. Couch, you state your name, sir?
Derek Couch. All right, keep your hands out of your pockets. Court does have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that defendant would be pleading no contest to count 2, the stated count 2 of operating while intoxicated, as well as the added count 3 of use of meth. Upon his successful no contest plea to those charges, count 1 would be dismissed. That's the court's standing.
That's correct, Your Honor.
Likewise, Your Honor.
May I have him sworn?
Raise your right hand.
Counsel, has he signed an advice of rights form?
I'm about to have him sign it, Your Honor.
All right. Have him sworn, please.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Derek Couch.
All right. Sir, it is this court's understanding you're going to plead no contest to 2 charges. Is that your understanding?
Yes.
First charge is the stated count 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order any rehabilitative services or community service the court deems necessary. Court could also order your vehicle immobilized. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? The other count is the count of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is? All right. 2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these 2 charges. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Lack of memory, Your Honor.
All right. I do have to further advise you, sir, that while I'm taking your plea in this case, I would not be your sentencing judge. And you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes.
All right. Still wish to plead no contest?
Yes.
To the charge of operating while intoxicated, how do you plead?
No contest.
To the charge of use of methamphetamine, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Counsel, I have been provided and have reviewed Ypsilanti Police Department report for their case number 22-262. Any objection to the court having reviewed that report?
No objection, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied these offenses? Have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied. Thank you.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's pleas of no contest. Counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 31st at 10 a.m. in Judge Bar.
July 31st, 2024, 10 a.m. before Judge Barr. On with its conditions will continue. Thank you, sir.
I do the sentencing judge.
Pardon? Okay, we'll put it in. Those called the case, People versus Ayad Abulas. Did you put a ticket on that window?
Morning, Your Honor.
Did I have a prosecutor say anything?
Yes, you did. And you're talking on behalf of people.
All right.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr.
All right, your name, sir?
Iyad Abeles.
All right, I have before me a plea form that indicates the defendant would be pleading no contest to an added count 6 of receipt and concealment, 200 to 1,000 to 1 year offense. Upon a successful no contest plea to that charge, counts 1 through 5 would be dismissed. There is further an agreement of no delay, deferred, no upfront jail, of course, which I cannot bind the sentencing court to. There is, however, an agreement of restitution in the amount of $1,219. That's the court's full understanding of the agreement.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Iyad Omar Abeles.
All right. Sir, it is the court's understanding that you're going to plead no contest to the charge of receipt and concealment of stolen property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that could become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is? All right. 2 things about it I have to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right. Basis for the no contest plea.
Potential civil liability.
Understanding all of that, sir, how do you plead to that charge?
No comment.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. Has he signed any advice of rights form, Ms. Gaines?
Oh, I apologize. Your Honor.
Yeah. All right. Sir, because you're not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes.
You are on, okay, which one?
Ann Arbor.
Probation?
Probation.
You understand that your plea in this case could be a violation of that probation?
Yes, sir.
You understand that if it is considered a violation of that probation, the court, the 15th District Court could sentence you to the maximum allowable under the other charges?
Yes, sir.
And understanding that, you still wish to plead no contest to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
Okay.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 23-8363. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 6. Counts 1 through 5 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
July 19th at 8:30 before Judge Perry.
July 19, 2024. What time, I'm sorry?
8:30.
8:30 before Judge Perry. Bond will continue. Thank you.
Thank you.
Court calls the case, people versus Rayshawn Ellis.
Assistant Public Defender Hannah Apple hearing on behalf of Mr. Ellis. Mr. Ellis, will you please state your name for the record?
Just kidding.
What are we doing?
Your Honor, we're asking that this matter be set for a preliminary determination, and I did wish to address bond on behalf of Mr. Ellis.
Discovery is complete.
To our understanding, yes.
People have their witnesses available the 25th.
That's fine, Your Honor.
Preliminary examination will be set in person June 25th, 2024, 9 a.m. before Judge Barr. As to bond.
Your Honor, I did have an opportunity to speak with Mr. Ellis yesterday, as well as his mother, at great lengths. Mr. Ellis is scheduled to be sentenced this afternoon before Judge Slay on a resisting and obstructing. However, I would bring to the court's attention that he is enrolled at the University of Phoenix. I spoke with his mother regarding a house arrest tether. We would have no objection to that. He is gainfully employed as well, doing construction work out of Canton. I do think that it is important to note that he was arrested on a driving while license suspended warrant that was incorrectly issued. That case was since dismissed this week before Judge Barr because his license was in fact restricted at the time when he was pulled over, not suspended. And that was
Really sick of hearing about driving while license suspended, but go ahead.
I'm sorry.
No, go ahead.
I do think that that's important to note, as Mr. Ellis was not aware of the warrant, as a warrant should never have issued because he did have a restricted license at the time. We are asking the court to.
Was he on bond then when this occurred?
Yeah, he was, yes.
For R&O.
For also R&O?
That is correct.
Okay, go ahead.
Your Honor, we're asking the court to consider a release. His family is here in the courtroom. I spoke at length with his mother and father. We would have no objection to a house arrest tether, but we would appreciate and ask the court to consider that release.
The problem is he was on bond at the time that this offense occurred. Otherwise, I might consider that request, but I'm not going to change the bond at this particular juncture in light of that. And I understand what you're saying regarding the initial stop. I get all of that, but that I don't think necessarily excuses behavior. It may excuse the contact, but not the behavior or alleged behavior. So motion for bond reduction is denied. Bond will continue. Certainly you can raise that again before Judge Barr. Mr. Ganatra, please.
Good morning, Your Honor. Mr. Ganatra, Senior Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to prevent conflict between this honorable court, the Office of the Public Defender. The Prosecutor's Office does not believe a conflict exists, but if there is one present, we waive for all the cases today between my office and the Public Defender's Office before this honorable court. Thank you.
Thank you, sir. Mr. Brown.
Good morning, Your Honor. Good morning. Gordon Brown, Deputy Chief Public Defender appearing. Your Honor, we likewise do not believe that any conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we waive that conflict so that this honorable court could hear these matters.
Thank you, Mr. Brown. Court, for its part, also does not believe there's a conflict either in interest of court rules or the cases to set there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case, People of the State of Michigan versus Maurice Anthony.
Mr. Ganatra, on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Davi Liba on behalf of Mr. Anthony. Mr. Anthony, could you state your name, sir?
Maurice Anthony.
Thank you, sir. What are we doing?
Your Honor, today will be requesting an adjournment in order to review discovery with Mr. Anthony.
Where are you located? You're in Livingston.
Yes.
Preliminary exam. How long do you, Mr. Anthony, how long are you going to be in there? Do you know?
Just to tomorrow.
Just till tomorrow? Okay. Then what I'll do is I'll set it out to the 2nd.
PCC, Your Honor.
Yes, for PCC. I'm sorry, not a preliminary examination. Probable cause, July 2nd, 2024, 9 a.m. or as your invite indicates, bond continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case, People versus Mark Austin.
Mr. Ganatra for the people.
3 cases.
Public Defender Hannah Apple appearing on behalf of Mr. Austin.
Mr. Austin, can you state your name, please?
Mark Austin.
Thank you.
Your Honor, my understanding is that he still remains incompetent. We did not receive a report regarding an update, so we would ask for an adjournment.
I do have a copy of the report to support, have a copy in its file.
The June 10th report?
The report is dated June 10th, sir.
Yes, sir.
Okay. I can hand a copy to Miss Apple.
Thank you.
I'll actually give it to her because I have an electronic copy. But the people don't have any objections to the adjournment request, but we also agree with the findings of the report. They believe that it's sort of. I'm just giving the thumbnail for Miss Apple's benefit.
All right, but you're not looking to have that happen today.
Correct.
All right. One other issue, and I'm not sure what we do with this because he's incompetent at this point, or at least been determined to be that. He also has an arraignment on a knee charge.
Okay.
That's also assault on a prison employee.
Yes.
Your Honor, I have no objection to adjourning that if that's what counsel wants.
All right. So the competency hearing, I'll adjourn. How long did you want?
Your Honor, 90 days. That's too long.
What are you trying to accomplish within the 90 days, I guess? Are you?
I haven't had a
doing
chance to
IME?
review the report, but if,
Are you looking to make an assessment on an IME?
oh, understand. Your Honor, just 2 weeks so that we can review that.
Oh,
Thank you. Sorry, I was misunderstood. Thank you.
why don't we just do July 2nd, 2024, 9 a.m. On that, I'll also adjourn. I'll adjourn both cases and the arraignment to that date.
Understood.
All right. Okay, thank you.
Thank you.
Thank you, Mr. Austin. Court calls the case, People versus Kimberly Ashley.
Morning, Your Honor, Mike Gaddy, Assistant Public Defender on behalf of Ms. Ashley, who should be here via Zoom.
Yes, I am.
State your name.
Kimberly Ashley.
All right, what are we doing on this?
Your Honor, I've had a chance to discuss this matter with Mr. Ganatra and with Ms. Ashley. There's a little investigation that I'd like to do on this matter. I'd ask the court for a brief adjournment so that we can do that.
All right, and she's gonna need video next time she appears, if she appears this way, but probable cause conference
Okay.
will be adjourned to July 2nd, 2024, 9 a.m. Bond will continue.
Thank you.
Thank you. Court calls case, People versus Brandon Fortson.
Andrew Solicitor on behalf of the people. Assistant Public Defender Dovie Leap on behalf of Mr. Fortson, who's approaching to my right.
Your name, sir?
Brandon Force.
Thank you.
Your Honor, we would like to set this matter for preliminary examination, please.
Is discovery complete?
To my knowledge, Your Honor.
People have their witnesses available the 25th.
Yes, Your Honor.
Preliminary examination will be set in person June 25th, 2024, 9 a.m. That is before Judge Barr. Bond will continue. Thank you.
Thanks, Your Honor.
Court calls case, People versus Emily Bates.
Hearing on behalf of Emily Bates is not present.
Not?
Correct, she is not here today.
Why?
I spoke with her father outside and he says that she has severe mental and physical ailments. And that's likely the reason we were not able to contact her. We'd request an adjournment, so to allow us time to contact her.
Although I don't normally do this, any responses to his request for an adjournment on this?
I don't have a response.
Never say I didn't do anything for Spartan Nation. Whatever the heck that is. I'll grant your adjournment. See if you can get her here. Probable cause conference will be reset July 2nd, 2024, 9 a.m.
Thank you, Your Honor.
Bond continue. You're welcome. Yes,
Sorry, Judge, what was
he
it?
has no idea what he just did. Huh?
That wasn't.
July 2nd. That was a miracle. He doesn't even know to be proud. Anyway, court calls the case, People versus Aaron Fromm.
Public Defender Dovie Leap on behalf of Mr. Fromm, is approaching to my right. Mr. Fromm, state your name, sir.
Aaron Fromm.
Aaron.
Good seeing you again. Good seeing you. All right. What are we doing?
Your Honor, we'd like to set this matter for preliminary examination, please.
Right, discovery is complete.
It is, Your Honor.
People have their witnesses available the 20. When are his other things set? What did we do yesterday?
Yesterday I got sentenced to the year with the MRT program, early release.
That's right.
But then I got one more on the 27th. I got a couple more cases.
Where are those?
Here.
You got
I think,
felony
Your Honor,
cases?
Your Honor, if I may, the one on the 27th is with Judge Washington.
With who?
Judge Washington, Your Honor.
Okay, so let's do this then. I'll set a preliminary examination in this case in person, June 25th, 2024, 9 a.m. I'll put this before Judge Washington since he's gonna finish it, okay? I don't think everybody in the world should be seeing Mr. Frown. Anyway.
I appreciate that.
Right, fine, we'll continue. All right, Mr. Frown, good luck. Court calls the case. People versus Kayla Garcia. Just came right out. No, you ain't nice.
Public defender representing Ms. Garcia. Your Honor, we have been.
Your name, ma'am?
Thank you. Ms. Garcia. Your Honor, we have been in conversation with the prosecutor's office and are hoping for a resolution. I do have here a referral for the mental health court. So we are asking for an adjournment for that to take.
Okay, so how much time do you think you need? I don't know what schedule they're on in terms of their.
Maybe 3 weeks, Your Honor.
Okay. Well, let's do it this way. Sign off. All right, let me set it for July 11th,
Thank you.
9 a.m. Bond continue. Thank you. Court calls case people versus Tishia Cobb. Mess that all up.
Andrew Childers appearing on behalf of the people.
They gotta do something about that. Yeah, I gotta have something done. Yeah, I know. He just walked out.
Brown, Deputy Chief Public Defender, being written on behalf of Ms. Cobb.
Your name, ma'am?
Natasha Cobb.
Can't tell you much. Thank you. All right, what are we doing?
None of there has been a plea conclusion in this matter.
I never wrote it up because nobody told me.
I'll adjourn it. Yeah.
I had made an offer, but I told the public defender, which was not Mr. Brown, to confirm that it would be accepted and I'd write it up.
All right, she's out, so I'll adjourn it to July 11th, 2024, 9 a.m. Or I can do the second. Which would you prefer?
Thank you, Honor.
Which would you prefer, second or the 11th?
The 11th.
The 11th, okay. July 11th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
That was nice of me.
You are so
It was
nice.
very nice.
Pardon, ma'am, what did you say?
You are so nice.
See? Just finally someone that appreciates you. Thank you. Court does call the case people versus Sharonda Griffin.
Nicholas Kozitsa on behalf of Sharonda Griffin.
Your name?
Sharonda Griffin.
Thank you.
Andrew Childers appearing on behalf of the people.
What are we doing?
We'd like to adjourn for further investigation into this matter.
How much time did you need, counsel?
3 weeks.
You really know. Yeah. Probable cause conference, July 2nd, 2024, 9 a.m. Bond continue.
Thank you.
All right. Thank you, ma'am. Calls case people versus Brandon Cole.
Nicholas Kozitsa on behalf of Brandon Cole, who is not here, who is. Sorry.
You're having a great day, aren't you, counsel?
Thank you.
You don't know what to do. What do you want to? Yeah, state your name, sir. Thank you.
Yeah, we'd like to adjourn this matter.
You
because
think?
we haven't been in contact with him until today. So,
Right now.
Yes.
Yeah,
correct.
we all witnessed it. Okay. Sir, make sure you get in contact with your attorney, okay?
I called him yesterday, but
You called him?
I called the office, yeah.
Yeah. Okay, well, they were probably busy preparing for today. All right. So I'll adjourn probable cause out to July 2nd,
Thank you.
2024, 9 a.m. Okay, make sure they have a good number for you, okay? All right, thank you. Court does call the case of the people versus Monty Hamilton.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Public Defender Jay Long on behalf of Mr. Hamilton, who appears to my right. Mr. Hamilton, can you please state your name for the record? Your Honor, we were just asking set for exam in this matter.
Have you received a copy of the amended complaint?
I have, Your Honor. And as to that, I apologize. We are going to be waiving a formal reading standing mute.
Waiving what?
We're waiving a reading of the new charges.
Oh, okay. So, sorry, excuse my language.
That's all right.
And we're just gonna set it for Cam, okay?
And in a range on counts
Tell us, Ms. Harris.
3 and 4. And
Thank you.
I'm just going to indicate the court's entering a not guilty plea.
Thank you, Your Honor.
Then, so all discovery is complete. I understand that the
Yes, Your Honor.
information that forms the basis of count 3 and 4 is not new information.
Correct, Your Honor. We were aware that this was gonna happen.
And would the people have their witnesses available the 25th? Preliminary examination, June 25th, 2024, 9 a.m. That is before Judge Barr. Defendant's bond will continue. All right. Thank you. Court calls the case, People versus Vasquez Davis.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Davis, who's here to my right. State your name, Mr. Davis.
My name is Vasquez Felon, David.
Thank you. All right, what are we doing?
Your Honor, I've had a chance to discuss this matter with Mr. Davis and with Ms. Tana. I'd ask the court for maybe a 3-week adjournment so I can explore specialty court participation for Mr. Davis.
No objection, Your Honor. I believe we're fairly close to resolution.
July 11th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.